Defenses to the enforcement of contracts. Now, you remember there are two things that fall under defenses to enforcement of contracts. The first is genuineness of assent, also called legal assent. And the second is the contract's writing requirement, also called form. During this section, you will learn, first, how to describe the importance of legal assent. Second, recall the elements of mistake, recall the elements of misrepresentation, recall the elements of undue influence, recall the elements of duress, describe the purpose of the statute of frauds, recognize the types of contracts that require a writing to satisfy the statute of frauds, recognize what a writing must contain to satisfy the statute of frauds, and finally, to describe the purpose of the parole evidence rule. Now we start off with genuineness of assent, also called legal assent. A party who demonstrates that he or she did not genuinely assent to the terms of a contract may avoid the contract. Genuine assent may also be lacking due to mistake, fraudulent misrepresentation, undue influence, or duress. Let's start off with mistakes. There's a difference between mistakes as to judgment of market conditions and mistakes as to facts, which is believing something is something other than what it is. Only under a mistake of fact can a contract be avoided. Now, with that said, there are two types of mistakes that we have to deal with. First is a unilateral mistake. A unilateral mistake occurs when one party is mistaken as to a material fact. A material fact is an important fact. It's a fact that is central to the reason why someone is entering into a contract. An example of a material fact would be you go to a car dealer to buy a car, a used car, and you believe that the car has 25,000 miles on it. In fact, the car has 250,000 miles on it. Now, here's the thing. Would you buy a car with 250,000 miles on it? Probably not. Would you buy a car with 20,000 miles on it? Probably. The mileage on a car would be a material fact. As a general rule, if the mistake is unilateral, the mistaken party has no right of relief. In other words, the contract remains enforceable. Now, there are two exceptions to this rule. Exception number one, the rule does not apply if the other party knew or should have known a mistake had been made. By way of an example, let's consider a general contractor. The general contractor is building a housing complex with 400 units, right? It's a massive project. And the general contractor needs to hire some subcontractors. So the contractor solicits bids from plumbing subcontractors. Contractor number one says they can do the job for $4 million. Contractor number two says they can do the job for $5 million. Contract number three said they can do the job for $4.5 million. And contractor number four says they can do the job for $500,000. Being frugal, the contractor takes bid number four, the lowest bid, for $500,000. only to find out after the submission was made that the bidding party had made a mistake. Well, in this instance, the mistaken party could avoid their legal obligation. They could get out of the contract. Why? The general contractor knew or should have known that a mistake had been made. First, as the general contractor, right, he or she should have had a real good idea about what the job was going to cost. Now, even if they didn't, if you take 4 bids in, $4 million, $5 million, $4.5 million, and then $500,000, that should raise a red flag. If the next closest bid is $4 million, how is it possible the job could be done so cheaply? So if the contractor did not in fact know, there was an indication that a mistake had been made. The mistaken party could avoid their contractual obligation. They could get out of the contract. Now, the second exception occurs if the mistake was due to a mathematical error not caused by gross negligence. Now, in order to determine whether the accident was caused by gross negligence or not, you have to look at two things: time and complexity. As a general rule, the more complex a job would be, the more time that should be allotted to coming up with your figures, your numbers. The simpler a job is, the less time is required to come up with your numbers. For example, let's say we go back to that same example I gave previously, right? I'm a general contractor. I'm building a housing complex of 400 units. I say, I'd like you to take the plumbing job. I want to know how much it's going to cost. You have 6 weeks to give me your figures. If at the end of 6 weeks, you came back and you gave me some figures that proved to be incorrect, the contract would be enforceable. Why? Your error was gross. You had enough time to check, to double check, to triple check, to give the numbers to your partner to check them after you checked them before you gave them to me. Now, conversely, if I said, I'd like you to take on this project, you have 2 hours to give me your numbers. Because the project is complex, it's a huge project, I didn't give you sufficient time to come up with the numbers, right? So if you made a mistake, it would be due to simple negligence, just not having enough time to carry all your decimal points and check your work. Conversely, if the project was small, let's say I'm building 1 3-bedroom family ranch home with 2.5 baths. Now, during your 25 years as a plumber, you built over 3,000 homes like this. If I said, how much can you do the job for? You got 2 hours to get back to me. That's sufficient time because it's one project that you've done over and over again. In fact, you should be able to tell me the price off the top of your head. In that case, if you made a mistake in 2 hours, the contract would remain enforceable because that was a sufficient period of time to come with correct numbers. The second type of mistake is a bilateral mistake. When parties to both sides of a contract are mistaken as to the same material fact, either party can rescind the contract. If you look at the example, you have 2 people that are entering into a contract to buy a vehicle. One person believes that the vehicle is a car. The other person believes that the vehicle is a boat. Now, because they've made a mistake about the same material fact, what type of vehicle it is, either party can rescind, can cancel the contract. Now, while it should be obvious, I'm going to explain this. A contract is a meeting of the minds. In essence, it's 2 parties agreeing to do exactly the same thing. If the parties don't agree to do exactly the same thing, guess what you don't have? A contract. And that's why when they make a mistake about the same material fact, either party can cancel a contract. When a mistake concerns the latter market value of the object of the contract, either party can enforce the contract. In the example, the buyer says, "What's the future value of this painting?" The seller says it'll be worth $10 million. So they both think it's a pretty good deal. They think it's going to go up in value. If, in fact, in 5 years, it's not worth $10 million, too bad, too bad, too bad. He could not get out of the contract. Why? They made a mistake regarding not what the contract was for, but the future value of the contract. And if we're going to be really honest about it, no one knows what the future will bring, so the contract remains enforceable. Fraudulent misrepresentation. Fraud affects the genuineness of the defrauded party's consent to the contract. Normally, an innocent party can either rescind the contract and be restored to his or her original position, or enforce the contract and seek damages for any injuries. Now, just so we're clear, if you can't tell from the background, basically, fraudulent misrepresentation is a lie. Now, the elements to fraud are the exact same as they were in torts, but let's go over them again. 1, there must be a misrepresentation of a material fact or condition with knowledge that it is false and reckless disregard for the truth. 2, there must be an intent to deceive. The reason why I'm telling you the lie is because I want you to believe it. 3, there must be justifiable reliance on the misrepresentation on the part of the injured party. And that simply means that there must be some reasonable basis for the injured party to believe the lie. And 4, in order to collect damages, the innocent party must suffer actual harm and actual injury based on the reliance on the misrepresentation. Now, here's the thing. There are some non-fraudulent misrepresentations, and in those cases, to rescind a contract for non-fraudulent misrepresentation, all of the elements must be proven with the exception of an intent to deceive. Examples of non-fraudulent misrepresentation are as follows. Innocent misrepresentation. If a person makes a statement that he or she believes to be true, but misrepresents material fact, the person is guilty of innocent misrepresentation. Remedies include rescission, but usually not damages. If someone tells you something that they actually believe is true, but it's not, they didn't lie to you. They did not intend to deceive you, right? That's why you can just cancel a contract, but you can't really sue them for damages in that case. Second, negligent misrepresentation. A misrepresentation is negligent if a person fails to exercise reasonable care in disclosing material facts, or does not use the skill and competence required by his or her own business or profession. Now, honestly, this kind of falls under the realm where They just didn't really give a damn. They didn't put the effort in. They did not do what they were supposed to do, right? If there's something wrong with something that you're buying and they fail to disclose it, that's important. That was negligence. Our next offense is undue influence. Undue influence occurs when one party has such influence over another party that the second party has no free will of its own. Undue influence occurs in relationships in which one party can greatly influence another, thus overcoming the other party's free will. A contract entered into under undue influence is voidable. Now let's talk about undue influence for a second, and let me give you an example. A lot of times you see undue influence with a parent and a child. Why does the child do what the parent tells him or her to do? Because that's mommy or that's daddy. Mommy, I don't want to. You have to. Why? Because I said so. If a parent convinces a minor child to enter into a contract that they don't want to enter into, that would be an example of undue influence. Mommy, I don't want to sign it. Shut up and sign it. The last offense under genuineness of assent is duress, duress, duress. Duress involves conduct of a coercive nature, such as forcing a party to a contract by threatening a party with a wrongful act. Generally, the threatened act must be wrongful or illegal. Being in need is generally not a circumstance that will lead to a finding of duress unless the party exacting the price created the need. Duress is both a defense to the enforcement of a contract and a ground for rescission. Let's talk about this for a moment. Duress involves conduct of a coercive nature. I knock on your door because I like your house, and when you open the door, I put a gun to your head, and I say, sell me this house for $5,000. What do? You sell me the house. You sign over the title to me, you take my money, and you get out. After you get to safety, what do? You sue to get your house back. You sue to make the contract void. Here's the question. Is that contract cancelable? Can you rescind it? The answer is yes, right? I threatened you with a coercive act. Had I not had the gun at your head, would you sell me your house for $5,000? Probably not, right? So that's wrongful or illegal. So when we say being of need is not a general circumstance, what does that mean? Well, when you say being in need, you're referring to financial hardship. Now, here's the thing. The law does allow people to take advantage of the financial hardship of others. All right, for example, you've probably seen those signs that say we buy used homes for cash. Well, anybody who calls up a number on a handwritten sign is probably pretty desperate for money, right? So when the buyer comes to the house, they've done some research and they know that you're behind on your mortgage and your house is about to be foreclosed on, your credit's going to be all gone. So you have a $300,000 house and they walk up to you, this is a lovely house, tell you what I'm going to do for you. I'm going to buy this house from you for $50,000 and I will take over your mortgage. If you agree, you walk away with $50,000 cash in your pocket and your credit doesn't get injured any more than it already is. Now, if you decide not to take me up on this offer, we both know what's going to happen. The bank's going to foreclose on the home, you're not going to have a house, and you won't have any money. What do you want to do? So the person who's in financial need accepts the offer, sells the house. Could they rescind the contract? The answer is absolutely no. Why? The buyer had nothing to do with the creation of that need. That was something that the seller did on his or her own. Now, had the buyer created the circumstances that caused the need in order to benefit from it, then the contract could be rescinded. We now move to the second defense to the enforcement of an otherwise valid contract, the statute of frauds, also known as the writing requirement for contracts. Now, what is the writing requirement for a contract? It's very simple. To be enforceable, certain kinds of contracts must be in writing. Even if both parties acknowledge an oral contract, it might not be enforceable. The primary purpose of this requirement is to provide reliable evidence of these contracts and a writing signed by the party against whom enforcement is sought. Now, this is really, really important. In order to sue a person for breach of contract, if the contract is in writing, it must be a writing that they have signed. If they haven't signed them, you cannot sue them. And if you think about this from just a common sense point of view, if I've got a contract in writing with your name on it that you haven't signed, how does the court know that you've ever even seen this contract? They don't. So if you want to sue somebody, they have to have signed the contract. Now, what kind of contracts have to be in writing? The first is contracts involving interests in land. Contracts for the sale of land, including physical objects that are permanently attached to the land, buildings, fences, trees, minerals, timber, etc. And for the transfer of other interests in land, such as mortgages or leases, must be in writing to be enforceable. Now, there is an exception, and this exception is partial performance. In a case involving a contract relating to the transfer of an interest in land, if the buyer has paid part of the price, taken possession, and made permanent improvements to the property, to the extent that the parties cannot be returned to their pre-contract status quo, a court may grant specific performance depending on the injury that will result if it did not. Now, pre-contract status quo simply means returning you to the position that you were in prior to entering into the contract. Sometimes that's very difficult. Other times that's impossible. By way of an example, let's say I had 4 acres of land to sell. Pristine woodland, beautiful trees, natural. I like you, you like me, you're interested in buying the land, but you don't have the full contract price of $25,000. What you have is $5,000, but I know you, I trust you, so I enter into an oral agreement with you to sell you my land for $25,000. You give me $5,000 now, and then we agree that you'll make monthly payments of $2,000 a month until you pay off the balance. You immediately take possession of the property and you clear off an acre and begin to build a home. 6 months go by, I get an offer of $100,000 for that same parcel. I remember that we had an oral contract, and I know that an oral contract is not enforceable for contracts dealing with interest in real property. So I sue you to rescind the contract to get my land back so I can sell it for $100,000. Here's the problem. To me, the land is much more valuable in its pristine condition. For you, the land is more valuable with the cleared space and the house that you built on it. Now, the quandary for the court is this. Is there any way they can put me in the position that I was in prior to entering into the contract? Is there any way they can put you in the position you were in prior to entering into the contract? And here's the thing. After you cut down old trees, how long does it take for them to grow back? If it took 100 years to grow the first time, it takes 100 years to grow the second time, right? So they can't return it to its pristine condition. Second, is the value of the property the same now that you put the house on it? For you, it's not. In a case like this, the court would order specific performance. They would order me and you to do what we promised to do in the oral contract. Why? Because there's no way to return us to the condition that we were in prior to entering into the contract. Contracts for the sale of goods. Under the common law, contracts for the sale of goods priced at $500 or more must be in writing to be enforceable. Now, there is one real big exception. Oral contracts for specially made goods may be enforceable if one, it's a specially manufactured good, that two, cannot be sold during the normal course of business, and three, affirmative steps towards completion have been made. What does that mean? Let's say I'm a tailor. I make fine garments, but I specialize in paraphernalia. Now, paraphernalia are things that usually fraternities and other organizations wear to identify themselves as members. Now, as you guys may or may not know, I'm a member of Omega Psi Phi Fraternity Incorporated. They also call us the Q Dogs. And we've got some pretty prominent members, right? One of the biggest is Shaquille O'Neal. Now, I'm sure you remember him. He was one of the greatest basketball players ever to walk the face of the earth. Well, since his retirement, he's gotten into a multitude of business ventures. And one of the things he likes to do every year at our conclave, right? That's our convention. He likes to put on a show. And because he likes to MC the show, he always wants to look good. So he calls me up and he says, Ron, I'd like you to make me something special for my showcase. And I said, well, what do you have in mind? He said, well, I want a special suit, right? I want a purple suit with gold pinstripes and a gold bullion vest. And I said, okay, we can do that. He says, no, that's not it. I want the gold threads to be 24 karat gold. This has to be a one-of-a-kind suit that no one's ever seen. So I look at him, and you know, Shaq's a big man, 7 feet 1 inches tall, weighs damn near 400 pounds. And I said, well, we can do it, but it's going to cost quite a bit. It's going to be $10,000, right, for the suit, because I have to buy the equipment, I have to buy the fabrics, and it's going to take some time to build it for you. He says, no problem. I'm Shaq. I got this. We shake hands. I go in and measure him. I order the fabrics. I begin construction of the suit. I get almost done. And now it's time for the final fitting. That's something that you always do with a custom suit to make sure it fits perfectly. Any final adjustments you have to make the person look spectacular. So I call Shaq up and I said, bruh, this is Ron. Your suit is ready. He says, Ron who? What suit? I say, Ron Claire, your frat brother who you commissioned to make a $10,000 suit for you. He said, I don't know what you're talking about. Hangs up the phone. I get furious. You know what I do? I call him. I decide to call him back. He goes, look, I didn't order any suit. Hangs up again. So I sue him for breach of contract. Would I win? Well, the statute of fraud says that a contract for the sale of goods, $500 or more, has to be in writing to be enforceable. As you remember, good is anything that is tangible and movable, so clothing clearly falls under that umbrella. Now, this suit is a $10,000 suit, clearly more than $500. However, it's a specially manufactured suit that I could not sell during the normal course of business, and affirmative steps towards construction have been made. Right? I'm almost finished with it. Now, think about this. It is a purple and gold pinstripe suit with a gold vest, made for a man who is 7 feet 1 inches tall and weighs 380 pounds. This is like a 72 extra long. Now, first question. How many men on the face of the earth are big enough to buy this suit? Not that many. And of the 2 or 3 of them who might be able to fit the suit, how many of them want a purple and gold suit? Probably none. Couldn't sell it during the normal course of business. Now, if this was something like a 44 extra long blue pinstripe suit,
I could probably sell it because you have quite a few guys that, wear 44 extra long, and they do pay $5,000, $10,000 for a suit. But this is not one of those. Second, I'm almost done. Now, of course, Shaq could come back. I could have got his measurements off the internet. But there's certain things that you know when you build a suit for somebody. For example, everybody has one arm that's longer than the other, one shoulder that's a little bit higher, right? And when you construct the jacket, there's a little bit of padding in one to make the shoulders look the same, right? It's tailored so it hangs perfectly, even though the body's imbalanced. How would I know these things had I not measured him? The courts would make him do what he promised to do and pay me my $10,000 for the suit. Now, the Uniform Commercial Code, the UCC, is a little bit different than the common law, right? The UCC deals with contracts between merchants, and because both parties are merchants, it requires a writing for the sale of goods priced at $5,000 or more, right? And the writing need only state the quantity. Now, the reason why this is a little bit different is because when both parties are merchants, when both parties are experts in the subject matter that the contract is about, they know the relative values, right? And they're in business. It's not like a private person buying something from a car dealer, right? It's like the car manufacturer selling to a car dealer, so they actually know the terms and conditions of the industry, right? So the details can be skimpier. Now, the exception to the requirement that the contract be in writing is that there had been a confirmation in writing of the contract. There's a confirmation of the writing in the contract, right? What does that mean? That means that I got on the phone, I'm a merchant, you're a merchant, and you ordered $6,000 worth of widgets from me via the telephone, right? And no harm, no foul. Let's say, okay, we'll get them out to you in 2 days, right? And you send me an email confirming the order, right? That's a written confirmation. Next, we have contracts guaranteeing the debt of another, also called collateral promises. Promises made by one person to pay the debts or discharge the duties of another if the latter fails to perform must be in writing to be enforceable. The key point is that the obligation is secondary, right? Well, what does that mean? That means that you're not a primary party to the contract, nor do you benefit directly from the contract. You're just trying to help out your friends by saying, if he doesn't pay his mortgage, I will. Now, what's the exception to this rule? An exception occurs if the main purpose of the guarantor in accepting the secondary liability is to secure a benefit for him or herself. If that's the case, the contract does not have to be in writing to be enforceable. Now you're saying, what does that mean? Let's explain. Let's say I own a professional bicycle team. You happen to be a bicycle mechanic. And I need 6 custom-made bikes for my racers, right? And there's a new metal that's come out that's lighter than titanium and much stronger. It just requires special equipment to machine. You're one of the best bike builders in the world, but this is very new, very innovative. You don't have the required equipment, so you have to go to the bank to take out a loan to buy the equipment that you need to manufacture my bikes. I go to the bank with you, and I tell the banker that if you don't pay this loan, I will. In this case, because you're only taking on this debt to benefit me, I can enter this collateral promise orally because I benefit directly from it. The 1-year rule is next. A contract that cannot, by its terms, be performed within 1 year must be in writing to be enforceable. Now, Cannot means impossible. Cannot means under no circumstance can it be performed within 1 year. That's what cannot means, right? If there's a possibility it could be performed in a year, it doesn't have to be in writing, right? Cannot is an absolute. For example, I hire you to sing in my club for 1 week, starting July 4th, 2021. If you signed that contract today, could you sing in my club starting July 4th, 2021 within a year? The answer is no. The answer is no, because the 4th of July 2021 is more than a year from today, so that would have to be in writing. Now, if I entered into a contract with you and I said I will give you $1 million if you take care of me for the rest of my life, that would not have to be in writing. Why? While it's unlikely, it is possible that I could die before the year is up. Now, really important, the 1 year period begins to run the day after the contract is made. And as I said, the performance must be objectively impossible. Not improbable, but impossible. Marriage, marriage, marriage. Promises made in consideration of marriage must be in writing to be enforceable. A unilateral promise to pay a sum of money or to give property, a dowry, in consideration of a promise to marry must be in writing to be enforceable. The same rule applies to both prenuptial agreements and antenuptial agreements. They must be in writing to be enforceable. Promissory estoppel. Some courts have used the doctrine of promissory estoppel to allow parties to recover under oral contracts that would otherwise be unenforceable under the statute of frauds. Admissions are pretty much a blanket exception where there are no specific exceptions. In most states, if a party against whom enforcement of an oral contract is sought admits in a pleading, testimony, or otherwise in court that a contract for sale was made, the contract will be enforceable. Admission, admission, admission. You're a really nice guy from the hinterlands of Alabama, and you come to New York, which you've never been to before, and I happen to be standing at the Brooklyn Bridge, and I say, I've got an opportunity for you. You probably see there are a lot of people, a lot of cars going by. My family's owned this bridge for about 100 years, and I'm on hard times, and I can do with some money, so I will sell you this bridge for $10,000. You can make your money back in less than a week, just charging $1 for each car and 50 cents for each person across the bridge. Now, you don't know any better, so you say that sounds like a pretty good deal to me. So I sign a piece of paper, turn the bridge over to you. I shake your hand, you give me the money, and I go on. You find out that I did not own the bridge. I couldn't have sold it to you. So you sue me for breach of contract. Now, in the court, on the witness stand, I say, well, Your Honor, I spent quite a bit of time studying the law of contracts, and I know that a contract dealing with interest in real property, which this bridge clearly is because it's permanently fixed to the land, has to be in writing to be enforceable. And while I did, in fact, orally agree to sell this bridge to the plaintiff, because there is nothing in writing, there's nothing to rescind. The contract remains in place. The judge looks at me and says, well, that was true until you did what? You admitted that you did it. Now the contract becomes enforceable. Sufficiency of a writing. What must be in a writing? The statute of fraud requires a writing signed by only the party against whom enforcement is sought. So both parties don't have to sign a contract. One of the things that you may have noticed if you've ever rented a car is when they give you the lease agreement, you sign it, the agent does not, right? If you do anything to the car, what will they do? They will sue you to enforce the contract. You signed it, so you're stuck. The signature can be no more than an initial, and the initial can be anywhere on the writing. Now, a lot of contracts where they have clauses that may be somewhat oppressive, somewhat against the interest of the signing party, not only do they make you sign those contracts on the bottom, they make you initial those special places, right? Once again, I think about renting cars or renting a U-Haul, right? They tell you to inspect the vehicle, and you have to initial the box that says there's no damage to the car. So if you bring it back with any damage, it's on you. Now, what exactly constitutes a writing? Any confirmation, invoice, sales slip, check, telegraph can constitute a sufficient writing. Right? Basically, it's any document that evidences the party's intent to enter into a contract. The writing does not have to consist of a single document to constitute an enforceable contract. A lot of times you have multiple communications between parties by way of email. I send you a letter inquiring on the availability of green, purple, and blue widgets. You say that you do in fact make green, purple, and blue widgets. So I say, I would like to purchase 1,000 green widgets, 2,000 blue widgets, and 5,000 purple widgets. What is the price? You say the price for green widgets is $10, the price for purple widgets is $15, and the price for blue widgets is $5. I say, sounds good to me, make it so. Well, these communications going back and forth evidence our intent to enter into a contract, and they would be constituted as one single agreement, not separate. They're all one contract. Now, what must be contained in a writing? Under the UCC, a writing need only name the quantity of the goods to be sold. Under the statute of frauds, covering transactions other than the sale of goods, the writing must contain the name of the parties, the subject matter of the contract, the consideration, and the essential terms with reasonable certainty. Now, once again, hopefully you remember, what are the requirements of a valid offer? Reasonably certain and definite terms. Who, what, when, where, quantity, if applicable, and price. All of these things must be included under the statute of frauds. Now, you notice you don't have to include them in the UCC, but once again, that's because the UCC deals with merchants, people who are expert in the subject matter of the contract, right? If you're not an expert, if both parties are not merchants, the common law controls, not the UCC. And once again, you must have those reasonably certain and definite terms. Who, what, when, where, quantity, if applicable, and price. Now, in some states, contracts for the sale of land must contain a price and a description of the property with sufficient clarity to allow them to be determined without reference to outside sources, right? If you've ever bought a lot in New York City, you will notice that there's always a description of the lot, the shape of the lot, and the dimensions of the lot as they run from east to west, north to south, and also a very definite location of the lot. The parole evidence rule. No evidence of prior oral or written negotiations or agreements or contemporaneous oral negotiations may be used to change the terms of a contract. Now, the reason for this is a written contract signed by both parties is perceived to be the final manifestation of all previous negotiation. You heard that, right? The final manifestation of all previous negotiation. The idea is, if it was important to you, you would have included it in the contract. That's the idea behind the parole evidence rule. The rule applies to all written contracts. Parole evidence is evidence, oral or written, outside of a contract that was not made part of the contract by reference. Now, once again, the final manifestation of all previous negotiation. In the eyes of the law, if something was really, really important to you, if you took the time to write a contract down and sign it, you would have included it. So all the things that you talk about prior to signing that contract are irrelevant under the parole evidence rule. Now, as with everything, there are exceptions. There are exceptions to the parole evidence rule. Parole evidence, evidence outside the contract, is admissible to show subsequent modifications to the contract. Now, subsequent means after. That a party was deceived into contracting by mistake, fraud, or misrepresentation. The meaning of ambiguous terms. What's an ambiguous term? I like the term vehicle. What exactly does vehicle mean? Any mode of conveyance is a vehicle. A skateboard, a bicycle, a plane, a truck, a helicopter, right? If you put blue vehicle in a contract, you can use parole evidence to show by blue vehicle you meant blue truck or blue motorcycle. To fill in gaps of incomplete contracts. Now, sometimes you purposely leave gaps in a contract. For example, I entered into a contract with you today to buy 2,000 bushels of apples from you in September at the market price. What's the gap? The gap is the September market price. This is May. September is several months away. We don't know what apples will cost then, right? So you can fill in that gap. You can introduce parole evidence to show the prior course of dealings between the parties or uses of trade. Well, parole evidence can be used to interpret the contract by showing how the parties have acted with one another in the past. Right? Easy example, I think one that I may have given before, right? I'm a paper supplier, you're a printer. I have a contract with you that runs for 4 years, right? That's 48 months, saying that I will give you paper on the first of the month, payment is due by the second of the following month. Every month, you paid me on the 15th, right? Based on what we've done over the course of our dealings, the court would interpret me as giving you a grace period, right? While I want payment on the second, you have up until the 15th to make payment, right? If I've let this go on time and time and time again and never complained. Parole evidence can be used to show a condition to which the existence of a contract is subject, right? Now, with some contracts, you have conditions of performance, right? You have conditions precedent. That's something that must occur prior to performance being due. For example, if I were to say to you, if I hit Powerball, I will give everybody in class an A. In order for you to require me to give you an A, I would have to hit Powerball. That's a condition precedent, right? Now, if I don't hit Powerball, you don't get an A. And finally, you can introduce parole evidence to show corrections to typographical errors or clerical errors. A lot of times people like to spell my name with an I. My name does not have an I in it. I could introduce evidence outside the contract, like my driver's license, to show how my name is actually spelled. That would be a typographical error or a clerical error, depending on your perspective.